have your seats, everyone. Your Excellency, Dr. Mohammed Irfan Ali, President and Commander-in-Chief of the Armed Forces of the Cooperative Republic of Guyana, the Honorable Madam Justice Yonette Cummings Edwards, OR, CCH, Chancellor of the Judiciary Acting, the Honorable Mr. Justice Winston Anderson, Judge of the Caribbean Court of Justice, Chairman of the CCJ Academy for Law, and Chairman of the Needham's Point Declaration Monitoring, Evaluating, and Facilitating Committee, Judges of the Caribbean Court of Justice, the Honorable Anil Nandlal, SC, MP, Attorney General and Minister of Legal Affairs, the Honorable Dale Marshall, SC, MP, Attorney General of the Republic of Barbados, the Honorable Madam Justice Louise Esther Blenman, Chief Justice of Belize, the Honorable Madam Justice Alice York Suhan, President of the Court of Appeal of Turks and Caicos, Judges of the Court of Appeal of the Supreme Court of Judicature, Judges of the High Court of the Supreme Court of Judicature, Mrs. Shalimar Ali Haq, SC, Director of Public Prosecutions of Guyana, Ms. Donna Bab Agard, SC, Director of Public Prosecutions of Barbados, Mrs. Paula Vanessa Llewellyn, KC, Director of Public Prosecutions of Jamaica, Mr. Roger Gaspard, SC, Director of Public Prosecutions of Trinidad and Tobago, Mr. Adlai Smith, Director of Public Prosecutions of St. Kitts and Nevis, Mr. Nigel Hawke, Solicitor General of Guyana, Their Excellencies, members of the Diplomatic Corps, Honorable Ministers and members of Cabinet of the Government of the Cooperative Republic of Guyana, members of Parliament, Mrs. Suwana Lovell, Registrar of the Supreme Court of Judicature and Deputy Registrar, Ms. Giselle Thomas Roberts, Deputy Registrar of the Caribbean Court of Justice, Commissioners of Title of the Supreme Court of Judicature, Chief Magistrates and members of the Magistracy, Mr. Charles Fongofat, SC, Chief Parliamentary Counsel in the Ministry of Legal Affairs, the Honorable Justice Lisa Schumann, SC, General Counsel for CARICOM, Ms. Haseen Sheikh, SC, Chief Public Defender of Trinidad and Tobago, Mr. Justice Carl Singh, Retired Chancellor of the Judiciary of Guyana and Chairman of the Constitution Reform Commission, Mr. Justice Charles Ramson, Retired Justice of Appeal and former Attorney General of Guyana, Retired Judges of the Supreme Court of Judicature of Guyana, Dame Janice Pereira, Retired Chief Justice of the OECS, Mr. Clifton Hicken, Commissioner of Police of the Guyana Police Force, Mr. Nicklin Elliott, Director of Prisons, distinguished speakers, panelists, and presenters, Mr. Ruggles Ferguson, KC, of the Organization of Caribbean Commonwealth Bar Associations, Ms. Pauline Chase, Vice President of the Bar Association of Guyana and members of the Bar Council of the Bar Association of Guyana, Mr. Paul Francis, President of the Grenada Bar Association, Ms. Shellon Boyce, Director of the Guyana Legal Aid Clinic, members of the Inner Bar, members of the Outer Bar, Ms. Azina Bash, Registrar of Deeds, Mr. Riza Manraj, Registrar of Commerce, Ms. Lorena Solorzano Salazar, Country Representative, and other representatives of the Inter-American Development Bank, Professor Justice Kenneth Benjamin, Head of Department of the University of Guyana Law Program, Professor Velma Newton, Head of Department of the University of Guyana, West Indies Cave Hill Campus, delegates from Barbados, Belize, Jamaica, Grenada, Suriname, Trinidad and Tobago, France, and the United States of America, and of course right here in Guyana, other members of the legal fraternity, students of the Hugh Wooding Law School, students of the University of Guyana, other specially invited guests, or audience viewing live on the Department of Public Information and other online virtual platforms, members of the media, ladies and gentlemen, good morning. That did deserve an applaud. That was a mouthful. A very warm welcome to the first legal conference on criminal justice reform, advancing the Needham's Point Declaration. My name is Kiyomo Griffith. I'm an attorney at law, and together myself and Ms. Shoshana Lal, the Assistant Solicitor General in the Attorney General's chambers, we will be your conference chairpersons over the 2 days. I especially want to welcome the delegates who traveled all the way from sister states around the region to be here. And before we delve any further into today's formal ceremony, I want us to stand and observe a moment of prayer and reflection on our brothers and sisters in the region who faced and are still overcoming the effects of Hurricane Beryl. Thank you all. You may have your seats. In October 2023, this region's key criminal law stakeholders convened in Needham's Point, Barbados, for the CCJ Academy for Law's 7th biennial conference. At this conference, participants and leaders in criminal justice reform shared experiences, identified issues, proposed solutions, and engaged in robust discussions, which resultantly led to the adoption of 39 declarations as best practices and recommendations for achieving a modern criminal justice system. Ladies and gentlemen, such a progressive undertaking in the fight against crime and injustice is deserving of an applaud. In his opening remarks at the conference in Barbados, Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, underscored that an inefficient criminal justice system has dire consequences for the cohesion of the social fabric, for the economy, and for the rule of law. His Honor begged the question, how do we go about addressing the problem? His response is timely now as it was then. He stated, we must first recognize that the criminal justice system is an intricate network of actors and systems comprising multiple stakeholders. We have police and prisons and prosecutors, lawyers and judges, courts and legislatures, probation and welfare departments, to name a few. Each has their own role and jurisdiction and priorities, but there must be at least a basic level of coordination among the various players that comprise the system if the system as a whole is to be effective. The theme of this conference, is criminal justice reform, advancing the Needham's Point Declaration. I assure you, ladies and gentlemen, that we have a dynamic conference planned for you with speakers, presenters, panelists, and criminal justice reform leaders as far north from Jamaica, the land of wood and water, and further west from Belize, the land known as the Jewel, or 50 minutes away aboard BW 526 from Trinidad and Tobago, the land of Carnival, Doubles, and Shadow Benny, or right here in Guyana, the CPL-winning oil-producing giant, where we say chicken before the curry. With these few words, ladies and gentlemen, please help me make way for the Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlal SC, who I will challenge this morning to keep his welcoming and opening remarks shorter than his Day 2 presentation. Please welcome him.
Thank you, Mr. Chairman. Good morning, ladies and gentlemen. And as you would expect me to do, I will seek your leave to take advantage of the protocols so expansively and elegantly established by our competent Master of Ceremonies. However, it is incumbent upon me to recognize His Excellency, Dr. Mohammed Irfan Ali, the President of the Cooperative Republic of Guyana, the judges of the Caribbean Court of Justice, the Chancellor of the Judiciary of Guyana, and heads of judiciaries across the Caribbean, attorneys general and other ministers of cabinet, Justice of Appeal of Guyana and the Caribbean, the Director of Public Prosecutions of Guyana and the Caribbean, our Chief Parliamentary Counsel, our Solicitor General, members of the Diplomatic Corps, members of Parliament, officials from our developmental partner, the Inter-American Development Bank, former members of the Judiciary of Guyana and the Caribbean, the heads of our discipline forces, learned magistrates, professors of law, members of the inner and outer bar of the legal profession, other distinguished guests, special invitees. It is indeed an honor to be afforded the opportunity to offer these opening remarks at this first legal conference on criminal justice reform, advancing the Needham's Point Declaration. My first duty is to extend a warm Guyanese welcome to all of our visitors from across the Caribbean and further afield. And I invite my fellow Guyanese to extend to our visitors that special Guyanese hospitality for which we are famous. This conference is part of the Support for Criminal Justice System, the SGS project funded under a loan program by the Inter-American Development Bank and being executed by the Attorney General Chambers and Ministry of Legal Affairs of the Government of Guyana. The principal objectives of this program are to effect reforms in the criminal justice system of Guyana in order, one, to reduce the proportion of pretrial detainees, and two, to increase the use of alternative sentencing. The conception of the idea to host this conference coincided with the 7th Biennial Law Conference of the CCJ Academy for Law held in Barbados on the 20th of October 2023, out of which the Needham's Point Declaration was born. Upon an examination of the Needham's Point Declaration, I immediately recognized great similarities with the core objectives of the Support for Criminal Justice System project, which I felt should be the subject of a legal conference. I contacted the distinguished Justice Winston Anderson, chairman of the CCJ Academy for Law, and I floated to him the idea of collaboration between the Attorney General Chambers and Ministry of Legal Affairs of Guyana and the CCJ Academy for Law for the purpose of a proposed conference. Justice Anderson immediately agreed. A planning committee was quickly established of important stakeholders representing both Guyana and the CCJ Academy for Law to organize the conference. The rest is now history, and we are here. The conference, as the name suggests, is the first of its kind ever held in Guyana. It is my hope that it will not be the last. The realm of criminal justice and embrace other fundamental areas of law, such as civil practice and procedure, constitutional and public law, different facets of commercial law, oil and gas law, the environmental law, etc., and of course, the new frontiers such as artificial intelligence. Needless to say, every effort will be made to engage the CCJ Academy for Law and such like institutions in collaboration so that we attract the broadest possible participation from the region. As students of the law, we know too well that the law must remain organic and must be nurtured, shaped, and molded to meet the exigencies of an ever-evolving society and the dynamic human conduct it is intended to govern. On the converse, stagnation of the law will result in a societal evolution beyond the regulatory capability of the law. This resultant social advancement without a commensurate legal regulatory framework is what leads to a breakdown of law and order and consequential social chaos. Unfortunately, such is the legal and social reality in almost every jurisdiction across our region, with a spiraling rate of violence, crime, and ensuing social turmoil. With easy access to guns and ammunition, coupled with the availability of information and communications technology at the disposal of criminals, crime has become a very organized, complex, and sophisticated phenomenon across the region. In most jurisdictions, criminals often operate in gangs, even across borders, and they do so with uncanny ease and with an unacceptable degree of impunity. This stark reality was recognized at no less a forum than a summit of the heads of the Caribbean community, CARICOM, recently, where it was resolved that a special symposium be held to address crime and violence declared to be a public health issue in the region. In consequence, a confabulation was held at the Hyatt's Regency, Port of Spain, Trinidad, on the 17th and 18th of April 2023, under the theme, Violence as a Public Health Issue, the Crime Challenge. Several heads of state of CARICOM, along with attorneys general, national security ministers, directors of public prosecutions, judges, heads of law enforcement agencies, and other important functionaries were present. I had the privilege of attending as part of a delegation from Guyana. At that conference, the epidemic of crime and violence in the Caribbean was recognized as a threat to our democracy and the stability of our societies, which requires a response of a multifaceted nature involving all of society if we are to ensure the people of the Caribbean can exist in an environment of peace and security and safety. A number of resolutions emanated from that conference. They include, inter alia, a comprehensive overhaul of the criminal justice system in the region. The regional symposium was one of the catalysts for the CCJ Academy for Law hosting its 7th biennial conference in October 2023 in the Republic of Barbados, which birthed the Needham's Point Declaration. Under the caption Policy Interventions, that conference declared inter alia, and I quote, that crime be viewed as a public health emergency following the lead of the heads of government meeting in Port of Spain in April 2023, and that as a matter of urgency, each member state of the Caribbean community develops, adopts, and implements a holistic and inclusive criminal justice reform strategy, unquote. Expectedly, as was with the case with the law conference in Barbados, many of the legal issues, concepts, and thematic areas which emerge as resolutions from that important regional symposium are on the agenda for our forensic examination and juridical interrogation over the next 2 days. It is clear, therefore, that our discussions will not be of a jurisprudential academic nature, but will be analyzing fundamental legal issues of undoubted practical and pragmatic importance, already identified to be so integral to peace, stability, and legal order across the region. The importance of fora such as these cannot be overemphasized. They bring together the maker of the law, the interpreter of the law, the enforcer of the law, the practitioner of the law, and of course the subject of the law, in a singular engagement to critically analyze and scientifically examine the law and its application. The engagements of these different and disparate functionaries will ineluctably lend to a cross-fertilization of ideas and synthesis of experience that must compel to the formulation of a criminal justice reform strategy, adept and adroit enough to tackle the monster of crime facing the region. In our deliberations, it is incumbent upon us to recognize that we are operating in exceptional circumstances and we are confronting an extraordinary problem. Therefore, our discussions must be robust and candid, our ideas bold and innovative, and our recommendations pragmatic and futuristic. Conservative, conventional postures and positions will simply not fly. Extraordinary circumstances require extraordinary responses. In many respects, this journey has started across the region. It must now be accelerated. Introspection is required from all sides. Deficiencies identified must be admitted without procrastination. Remedial measures must be implemented with alacrity. Legislators must be swift to dispense with anachronistic legislation and replace them with modern ones that will bring into force new legal processes, some already tried and tested in many other parts of the world. These legislation must be crafted to contextually and resiliently confront the identified conduct that is offensive to the law and which results in social disorder. Those endowed with the functional power to interpret these legislation must do so recognizing the mischief which these legislation were conceived and designed to address. They would do well to observe the admonition of the Honorable Justice Peter Jamadar in the case of Tudd against Price, 2021, CCJ 2AJ, where his lordship stated, and I quote, "Contexts are legitimate aids to the interpretation and application of legislation. Law is not devoid of context, falling from some eternal and abstract ethereal place. It is human-made, arising out of and shaped by social, economic, political, and cultural contexts, and intended to serve particular purposes, interests, and agenda. This is its pragmatic reality. To understand legislative intent and meaning and to interpret and apply the law is therefore impossible without an application of its multiple contexts." Unquote. The legal fraternity must aggressively pursue continuous education in order to update their knowledge and keep abreast of new and emerging developments in the law. Practitioners must execute their duties with diligence and professionalism and must be always ready to offer legal and forensic assistance to the courts. Judges and magistrates must inject competence, impartiality, and efficiency in the discharge of their functions. Cases must be concluded within reasonable time. Adjournments must only be granted for good and sufficient reasons. Once a decision is made, the reasons therefore must be made available swiftly so that the appellate process can proceed with dispatch. Too often do we hear the cry across the region, "Justice delayed is justice denied." Governments must ensure that the judiciary is adequately resourced to enable the discharge of their duties with the requisite expediency. The program of this conference is impressive. It contains a compendium of a wide range of disparate and diversified areas of criminal law and facets of practice and procedure. It embraces certain modern, emerging, and innovative legal concepts. It highlights for discussion some of the crucial institutional problems afflicting the criminal justice system, such as delay and abuse of process. It even contains a session that will offer counsel to students who wish to pursue a career in the practice of criminal law. In short, it is a very stimulating and encompassing program. It therefore gives me great pleasure in wishing us all a most thought-provoking, exciting, constructive, and fruitful conference. May our deliberations be earnest and bring forth worthwhile solutions to the many challenges with which we are confronted. You have my best wishes, and thank you very much for your attention.
Good morning, ladies and gentlemen. We thank the Honorable Attorney General for his remarks. He did not stick to the time. We'll take it out from tomorrow's presentation. Ladies and gentlemen, I join with the Honorable Attorney General and my co-chair in welcoming you to beautiful, warm Guyana. Justice Anderson has given me strict orders that I'm not to say anything about him except that he is a judge of the Caribbean Court of Justice and a founding chairman of the Caribbean Court of Justice's Academy for Law. So, I don't want to be held in contempt of the Honorable Judge's orders. Please join me in welcoming Justice Anderson to the podium.
Thank you, Master of Ceremonies, and good morning to everybody. Protocol having been established, permit me to recognize the presence of His Excellency, the President of the Republic, fellow CCJ judges, heads of judiciaries, honorable judges, the Honorable Attorney General, eminent members of the head table, and to greet you all as colleagues in the law, distinguished ladies and gentlemen. The CCJ Academy for Law takes pleasure in being associated with the Honorable Attorney General and Minister of Legal Affairs of Guyana, Mr. Mohibir Anil Nandlal, SC, MP, and his chambers in co-hosting this important conference on criminal justice reform. It should be noted that the conference is made possible through the support of the Inter-American Development Bank, the IDB. The Academy is also very pleased that the conference has the physical support of the following judges, officials, and staff of the Caribbean Court of Justice: the Honorable Madam Justice Maureen Rajnorth Lee, the Honorable Mr. Justice Dennis Barrow, Mrs. Giselle Thomas Roberts, Mr. Ayindi Burgess, Mrs. Danielle McConney, Miss Jasmine Sargent, Miss Enika Onoa. The patron of the Academy and the President of the Caribbean Court of Justice, the Honorable Mr. Justice Adrian Saunders, has asked that I extend his profound regrets in not being physically present. President Saunders wishes the conference well. This is the first conference convened specifically to advance the Needham's Point Declaration on Criminal Justice Reform, Achieving a Modern Criminal Justice System, adopted on 20 October 2023 in Barbados. The declaration does not claim to be a new recognition of the problems plaguing the criminal justice system, nor does it purport to offer entirely new solutions to these problems. What it does hope to present is a comprehensive menu of recommendations, which, if actioned with energy and commitment, will produce a radical transformation in criminal justice. And the Academy keeps track of and encourages progress of this implementation through our monitoring, evaluating, and facilitating committee, co-chaired by Madam Justice Alice York Sohan, President of the Court of Appeal of the Turks and Caicos Islands. The Academy congratulates the chambers of the Attorney General, the IDB, the Conference Planning Committee, and all those who have worked so hard to make this day a reality. We welcome every participant here today, and we wish the conference every success. Thank you very much.
Thank you for your remarks, Judge. We're going to have a cultural item at this time. Ladies and gentlemen, please help me welcome the Dubraj Tassa Group and Eyes of the Ancestors Drumming Group. Please welcome them. I guess they're shy. So let me try that again. Please welcome them. I stayed way into the night choreographing that piece. So thank you for that last round of applause. Thank you, Dubraj, Tacit Troop, and Eyes of the Ancestors. An important part of preserving our culture, as you just saw on display there, is recognizing the work of those who have come before us. And the CCJ Academy for Law, they prepared a special book, and it's titled Legendary Caribbean Legal Practitioners, and it reflects on the work of legendary practitioners in the Caribbean. You're all invited to a special launch this afternoon, but before we get there, I want to show a premiere to what is going to take place this afternoon. So I'm going to ask our sound tech to take it away. You're going to focus on the screens where you will be able to view that premiere.
The Eminent Caribbean Jurists Awards recognizes and celebrates the outstanding contributions by lawyers to Caribbean development. This year, the Academy proudly recognizes and pays tribute to 48 legal luminaries represent 9 diverse jurisdictions across the Caribbean region. Their invaluable contributions are immortalized in a compelling book of essays, Legendary Caribbean Legal Practitioners, that succinctly chronicles their remarkable legacies.
And Honorable Dr. Anil Nandalal, Minister of Legal Affairs and Attorney General, other Attorney Generals of the Caribbean countries, and members of the judiciary, distinguished guests, colleagues, and friends. So it's a pleasure to represent the Inter-American Development Bank in this regional event. That this conference on criminal justice reform being held in collaboration with the government of Guyana and the Caribbean Court of Justice Academy for Law. This landmark event marks a significant forward in our collective efforts to advance the Needham Point Declaration and effect a meaningful change in the criminal justice system across the entire Caribbean. Today's dialogue is about justice reform from practical steps and institutional changes to advance the principles and commitments enshrined in the Needham Point Declaration adopted by participants of the CCJ Academy by Law in the 7th Biennial Conference in Barbados last year. This declaration is truly an embodiment of our shared vision for a more just and effective criminal justice system that reflects and serves the citizens of the Caribbean. We at the Inter-American Development Bank, we are pleased to be part of this conference. Our involvement affirms our commitment to fostering sustainable development through robust legal frameworks and enhance to the rule of law. A fair and effective justice system protects the rights of the citizens and ensures that when those rights are breached, the institutions entrusted by citizens will provide swift and appropriate remedies, regardless of someone's social standings or economic interests. The confidence that gives is that everyone is equal in the eyes of the law. So that's why we at the Inter-American Development Bank see justice as a transversal principle to all our efforts, and effective justice systems as the cornerstone of the economic and social development. We understand that laws and judicial policies must keep pace and with the ever-changing and modern realities of our time, while managing to maintain and uphold the ancient and sacred principle of justice and equality. So the Needham Point Declaration provides this comprehensive roadmap to making this a reality. So implementing these recommendations requires a concerned effort from all stakeholders, governments, legal practitioners, so civil society, and international development partners. I would say that I will commend and congratulate the efforts that Guyana has been doing in the several years. In Guyana, I would say that we have significant strides in this direction. That support has also allowed for the establishment of key institutional arrangements to govern and update the alignment of the country's laws with global legislative trends. As evident with our support to the Law Reform Commission, likewise the creation of the Ministry Restorative Justice Unit is another instance of substantive change in the way of criminal justice administration, can actively engage the opinions and participation of the public in the offering justice solutions. We also have seen the Ministry of Legal Affairs undertake no less than 12 pieces of legislations and amendments drafted under the program process that reflects the practical consultations and public review in an effort to improve the status quo. That series of legislative reforms undertaken at an unprecedented rate over the past 3 years represents one of the most ambitious efforts that we have supported in the Caribbean. Our institutional support has also facilitated the use of online cases management platform for 7 criminal justice agencies that continues to be customized by these agencies for increase of efficiency in judicial services delivery. In addition, we have been keen to recognize the institutions that are essential as a collective of individuals working together in accordance with established of rules and common-based knowledge. So working together, the training of more than 200 justice practitioners on alternative and pretrial detention, working together with the University of Guyana to institutionalize curriculum for training and more than 90 prosecutors and correctional officers so far. So the reform and strengthening the judicial ecosystem is essential, since the victims' rights are at the heart of this work, and we must ensure that victims are treated with dignity and respect, receive the necessary support and protection, and have a voice in the justice processes. This includes providing comprehensive services for the victims of crimes, ensuring their safety, and promoting restorative justice practices. So there is a comprehensive ecosystem that Guyana is working on, I would say. We are very and extremely happy with, for example, with the Hope and Justice Center that Guyana has developed. We trust that it will truly be the center of healthy social relationship, conflict resolution, and mental health in adjoining communities to support family violence. We also, we see this effort is a real restoration, innovative, and a strong example of sustained policies, coordinating investments of Ministry of Legal Affairs with Ministry of Home Affairs and Ministry of Human Services and Social Security, so everybody work together in a single platform to support justice in the communities. So that is in Guyana, and I will again commend, and I'm very happy to be the representative of Guyana in this time that the government is really committed to have an equal justice for all. At the regional level, the IDB has also been working at the forefront in pushing justice innovation for addressing crime and violence in the region. Crime and violence also affect not just the citizens, but also the economy. See, most of the Caribbean countries are looking at their economy are coming from the tourism. If you don't have a safe place, then the economy will be affected also. So, for example, in Trinidad and Tobago and also in Jamaica, our programs are focusing on youth, behavioral change, and reintegrating opportunities to correlate with a drop of gangs-related activities. For example, in Port Spain, I would say that homicides fell by 55% if we can compare to the 17 that fell nationally. And injuries on shootings declined by 20% in Port Spain versus the national 2%. So similar cases in Jamaica. So I would say those integral interventions need to continue. But also, is it interesting at the regional level how the justice system, to see the justice system and the legal aspect merge with the innovation to the digital, so creating a new ecosystem, undertaking effective changes, managing digital transformation of the criminal justice reforms. Digital justice is a future and crucial in enhancing the efficiency and transparency and accessibility of justice systems. So in conclusion, I will say that the IDB remains committed and to support these efforts under the new flagship program that we, under the request of the governors of the IDB for One Caribbean program, has prioritized 4 areas. Among one is the citizen security as one of the 4 pillars. The others are more related to climate change, food security, and enhancing the private sector engagement. But I would say that citizen security is crucial for the safety, but also for the development of the Caribbean region. So we keep committed to provide the necessary expertise and support that to realize transformative goals in this growth of the region. Thank you very much.
Thank you, Ms. Salazar, for your remarks. Madam Justice Yonette Cummings Edwards began her legal career as state counsel within the DPP chambers. In June 2000, she was appointed a judge of the High Court of Guyana, and in January 2008, she was elevated to the Court of Appeal. From December 2015, she acted as Chief Justice of Guyana, and in 2017, she was appointed Acting Chancellor, a position in which she currently serves. Madam Chancellor is the recipient of 2 national awards of Guyana for her recognition to outstanding contribution in the legal field, the Cassie Crown of Honor, and the Order of Roraima. Our Chancellor is a strong advocate of women's rights and equality. I end by quoting the Honorable Chancellor herself, and I quote, "In the judiciary of Guyana, there are more women than men as judges and magistrates, and women are at the highest levels of decision-making. The senior judicial leadership positions held by the Chancellor, the Chief Justice, Registrar, and Chief Magistrate are all women," end quote. A phenomenon fondly and generally referred to by the Honorable Attorney General as the era of the endangered species of men. Ladies and gentlemen, join me in welcoming our Chancellor, Madam Justice Cummings.
Thank you, Madam Co-Chair. The protocols haven't been established so ably by Mr. Griffith. I respectfully beg to adopt same, but safe to recognize the esteemed presence of His Excellency, the President of the Cooperative Republic of Guyana, Dr. Mohammed Irfan Ali. I also wish to recognize the members of the Caribbean Court of Justice, the judges of the Caribbean Court of Justice, our heads of judiciaries, former heads of judiciary, our esteemed judges from across the region, and our esteemed judges here in Guyana, and of course, our online audience. Good morning. A legal conference on criminal justice reform is an idea whose time has come. This modern approach allows us to discuss emerging issues, best practices, and the implementation of strategies for a robust, proactive, and ultimately a better criminal justice system that meets society's needs. We are heartened to see so many of our counterparts from across the Caribbean region and beyond take time off from presiding over cases, from writing judgments, from preparing legal opinions, and from prosecutorial responsibilities to be present here in Georgetown to discuss legal reform and the advancement of the Needham's Point Declaration. We may very well see the Georgetown Declaration emerge from our conversations and discussions by the end of this meeting. We are all aware, ladies and gentlemen, that the 7th Biennial Conference of the CCJ's Academy for Law, which was held in Barbados last year under the theme Criminal Justice Reform in the Caribbean, Achieving a Modern Criminal Justice System, birthed the Needham's Point Declaration. We are also familiar with the terms of that declaration, some 39 lofty standards and noble ideas that strike at the core of our criminal justice system's deep-seated issues and challenges. The realization of the goals in the Needham's Point Declaration will undoubtedly result in peace, order, and good governance. It will be also a fillip for societal and economic development. It will foster citizens' security. It will also promote consistent adjudication of matters and address what Justice Anderson called an alarming epidemic of crime and criminality that has engulfed much of the Caribbean. His Honor made these remarks at the last conference in October, and he said that many of our citizens simply do not feel safe in their homes, at work, or in public spaces. At the same time, persons accused of crimes are sometimes deprived of their freedom. These and other features of our criminal justice systems are not acceptable, His Honor said. They must be reformed. There must be swift justice for the guilty, so there's a correlation between crime and punishment and the public's perception. And he's importantly stressed the fact that it is for all victims, it is time, rather, for all victims of criminal justice to have real justice. The Daily Express of March 7th of this year from Trinidad and Tobago had this caption, "Court decisions favoring criminals." In my view, it is a fair statement and an assessment of the views out there, and also reflective of the views of some members of society here in Guyana. Prime Minister Rowley was attributed in that piece to saying, and I quote, that the general sentiment, I think, is that the criminals feel better off in the courts than out in the streets, because sometimes one gets the impression that the care and attention of the rights of the criminal supersedes the trauma of the victim. Our society, perhaps emblematic of the wider Caribbean, has a punitive approach towards accused persons. Traditionally, sentencing has focused on punishment rather than reform. Recent cases, particularly those coming from the Caribbean Court of Justice, emphasize rehabilitation. We must interrogate whether this approach adopts a softened crime policy or a slap on the wrist, or whether it addresses the core issues facing us. Cases like the Queen against Ball, Radsrick, and Thomas, Ramphal and Thomas, coming from this jurisdiction and Radsrick from the New Zealand jurisdiction, offer some assistance on the way forward. And I quote from Thomas, where the court said, "In deciding the appropriate sentence, a court should always be guided by certain considerations. The first and foremost is the public interest. The criminal law is publicly enforced, not only with the object of punishing crime, but also in the hope of preventing it." And the court went on to say that the public interest is indeed served and best served if the offender is induced to turn from criminal ways to honest living. And some similar sentiments expressed by Fair J in Raddick case is worth repeating, and I quote again, if a court is weakly merciful and does not impose a sentence commensurate with the seriousness of the crime, it fails in its duty to see that the sentences are such as to operate as a powerful factor to prevent the commission of such offenses. On the other hand, justice and humanity both require that the previous character and conduct and probable future life and conduct of the individual offender must careful consideration, although this factor is, if necessarily, subsidiary to the main considerations that determine the appropriate amount of punishment. In short terms, I'm thinking that what those judges are trying to say, there must be a balance. We know of the biblical story of Cain, who received punishment for murder of his brother, Abel, and he led a defense claiming ignorance of his brother's whereabouts, famously stating, "Am I my brother's keeper?" His punishment was severe. He was told, "You are cursed from the earth. You will till the ground. It shall not yield its strength to you. You shall be a fugitive and a vagabond on the earth." Cain then said, "My punishment is greater than I can bear," leading to a plea of mitigation and tempered punishment. We must temper justice with mercy, but we must also strike that necessary balance. That balance is critical. It is important. Our criminal justice system has already seen evidence of the implementation of some of the Needham Point Declaration. Just days ago, there was the passage of the Criminal Law Procedure Paper Committal Bill 2024 in our Parliament, and it seeks to abolish preliminary inquiries. It was a significant step. Paper committal will replace preliminary inquiries, and it will save precious time for committals, time on remand, time for hearing cases, and of course, importantly, economic savings to the state. So we are implementing Needham, and therefore we are poised for great efficiency in our justice system. We must not only talk the talk, but we must also walk the walk. Rhetoric and meaningful action must go hand in hand. Reform does not fall from the sky. We have to work hard to implement it. The coming together, therefore, of legal minds in this era can reap enormous benefits for each of our judiciaries represented here. It could reap enormous benefits for each of our territories in the Caribbean and for citizens globally. We need to have this meeting of minds more often. Our meeting here in Georgetown over the next 2 days is a concrete manifestation of our commitment to advancing the Needham Point Declaration. We all deserve a round of applause for making it to round 2 of Needham's advancement. We say welcome to Georgetown, Guyana. Welcome to 83,000 square miles of beautiful Guyana. As judicial officers, thank you. As judicial officers, we have shared goals, and we must work collaboratively to navigate the challenges, embrace best practices, and implement policies and laws towards accomplishing a better criminal justice system. We are duty-bound to so do. I thank you for the courtesy of listening.
Thank you, Madam Chancellor. Thank you for sharing the ways in which we are already encouraging reform in the criminal justice system and honoring the declarations taken in Barbados. We do look forward to the Georgetown declarations, I should say. Chancellor, I also want to thank you on behalf of all my colleagues here for giving us the adjournment this morning and tomorrow so that we don't have to miss this meeting today. It's also pleasing to see that we have a full complement of High Court judges in the room today. I think that is also deserving of a round of applause. Madam Justice Esther Louise Blenman was called to the bar in Guyana in 1988. She is Guyanese. Her legal career began in Guyana, where she served in various capacities, including acting Deputy Solicitor General in the Attorney General's Chambers, acting magistrate, and a lecturer in law at the University of Guyana. In September 2000, Justice Blenman was appointed as the Solicitor General in St. Lucia, a post she held until she was elevated to the bench of the High Court of the Eastern Caribbean Supreme Court in 2003. Justice Blenman was appointed a Justice of Appeal in the Eastern Caribbean Supreme Court in 2012 and served in that capacity for 10 years. In 2022, Justice Blenman was appointed Chief Justice of Belize. Ladies and gentlemen, let's give a warm welcome home to our very own Madam Justice Esther Blenman, Chief Justice of Belize.
Thank you, Mr. Chair. Permit me to adopt the protocol that you have so ably established, but however, I must recognize the presence of His Excellency, Dr. Irfan Ali, President of the Cooperative Republic of Guyana, and the judges of the Caribbean Court of Justice, the chair of the CCJ Academy for Law, Justice Anderson, Honorable Madam Justice Rajnath Lee, and Honorable Mr. Justice Barrow. Also, the Chancellor of the Judiciary, Honorable Madam Justice Yonette Cummings, Attorney General and Minister of Legal Affairs, the Honorable Mr. Mohabir Anil Nandlal, Senior Counsel. Honorable judges from across our beautiful Caribbean, distinguished ladies and gentlemen, a pleasant good morning to all of you. I am always happy to be home in the country of my birth. It is my distinct honor to deliver this keynote address at the first legal conference on criminal justice reform, advancing the Needham Points Declaration. I thank all those who have played a role in organizing this very important conference. I am delighted to share with you Belize's barrier-breaking experiences in advancing the CCJ Academy for Law Needs and Points Declaration while reforming the criminal justice system. Over the next 2 days, we will be discussing the declaration and connected matters that concerns the criminal justice reform and ways to improve the delivery of justice. It is no secret that the criminal justice system in Belize was plagued with many difficulties at different stages, which led to a backlog of cases. In the magistrates' court, there were serious delays in the dispensation of justice. Preliminary inquiries took as long as 2 years to be completed. Police-prepared case files left much to be desired. Judges at all levels were said to have been granting adjournments too readily, thereby protracting the timely completion of cases. Cases were not properly case managed, and therefore trials took unnecessarily long to be completed. In some cases, a trial would take as much as 6 months to even a year. In Belize, murder, manslaughter, and sexual offenses are tried by judge alone, and written decisions in these cases are mandated by Section 65C1 of the Indictable Procedure Act. These cases are usually given priority. Judge-alone trials are usually shorter and more efficient than jury trials. However, a few judicial officers were not rendering judgments in a timely manner as required. Also, criminal appeals from the magistrates' courts were largely left unattended. Pretrial detention left much to be desired. Social inquiry reports took an inordinate length of time to be provided to the court, thereby further delaying the completion of cases. These issues and inefficiencies dovetailed. Their most obvious impact was that the remand population steadily increased, forming 50% of the prison population, with detainees on remand for prolonged periods of time. It was clear that efficient access to justice was being undermined by delays within key stages of the criminal justice process. This state of affairs coincided with high levels of crime in Belize, which eroded public confidence in the criminal justice system. As indicated, my task is to speak to you about how the situation in Belize and how the Needham Point Declaration has provided the gold standard for the judiciary and other key stakeholders to address the difficulties that we have there. I will share with you how we are breaking through barriers and shifting paradigms in the administration of justice without the immediate need for additional financial resources. To confront the challenges in the criminal division of our senior courts, we audited the cases, and this revealed serious problems. The picture painted by the audit was worrying. There were criminal cases, as I alluded to, as old as 12 years in the High Court and 6 years in the Court of Appeal, as well as hundreds of dormant inferior criminal appeals with files as old as 7 years. Having assessed the difficulties, the Office of the Chief Justice, in consultation with relevant stakeholders, formulated a strategic plan which focused on judiciary-led initiatives to transform the criminal justice system. Among those initiatives were dedicated recommendations for improving the delivery of justice and addressing backlog reduction. The scope and reach of those initiatives were, however, limited, as the judiciary is but one institution in the criminal justice system and has no supervisory power over the other independent entities within the system. Meaningful collaboration with all stakeholders was therefore crucial to address the issues that had been identified. I was privileged to have attended the CCJ Academy for Law 7th Biennial Conference on Criminal Justice Reform in October 2023. Our adoption of the Needham Points Declaration at that conference provided a gateway for that collaboration between criminal justice stakeholders. On the 4th of December 2023, I established a permanent criminal justice board in the Office of the Chief Justice to operationalize the best practices, recommendations, and standards set by the declaration. The board proved to be the solution needed to bring all stakeholders together. It is multidisciplinary and interdisciplinary. It consists of representatives from the clergy, the forensic department, teachers, doctors, the Director of Public Prosecutions, the Attorney General, the Judiciary, the Defense Bar, the Commissioner of Police, the Magistracy, the Prison Department, social workers, and education officers. At the forefront of the board's work is dialogue between stakeholders outside of their respective silos to decrease distrust and achieve the speedier dispensation of justice. Acceptance of collective responsibility for the poor state of the criminal justice system was a precondition for the successful work of the board. 7 subcommittees were established to utilize the declaration and identify the reasons that contribute to the backlogs at various stages in the system. There was to be no finger pointing. This augured well for collegiality and mutual respect, and has resulted in tremendous buy-in and support from all criminal justice stakeholders. The subcommittees were largely chaired by judges of the High Court, most of whom served on at least 2 committees. They were co-chaired by the Director of the Public Prosecutions, Director of Forensic Departments, magistrates, Defense Counsel, and other members of civic society. At the end of the subcommittee's work, detailed reports were provided to the Office of Chief Justice. The analysis of the reports revealed several barriers to the delivery of justice. Among them, matters which were known before, such as the overuse of pretrial detention, the need for more robust pretrial engagement tools, such as plea discussion and agreement, the failures of magistrates to provide reasons in a timely manner, the shortage of criminal defense lawyer, the overuse of adjournments, and generally the slow pace of criminal trials, which was coupled with the delay in the provision of social inquiry reports and other pre-sentence materials. It was also discovered that bail applications were only being heard by judges 1 day a week. From the reports, a range of training, legislative, process, research, and long-term solutions were distilled. The short-term solutions are being set in motion. The fruits of the collaborative approach the board has taken in the operationalization of the declaration are yielding great results. I will mention a few. We embarked on robust and facilitative case management training of judges to encourage comprehensive and attentive case management before and during trial to aid with the swift dispensation of justice. Our reinvigorated approach to criminal case management has afforded judges, the prosecution and defense counsel, the facilities to telescope the evidence before the court. The most immediate result is that less adversarial practices are being deployed by counsel, which augurs well for the speedy justice and less protracted trials. With the help of vigorous and robust case management processes, issues are narrowed, resulting in criminal trials being more streamlined, and they are substantially shorter. It would surprise you to learn that the average murder trial now lasts for 1 week. A sexual offense case is completed in a few days on an average, and that is true. The declaration has provided much-needed impetus for criminal justice reform. Bearing in mind the robust time standards set by the declaration, the Office of the Chief Justice issued a directive to ensure that old cases are heard alongside new cases. The High Court judges have been working assiduously to accomplish this. Thankfully, most of the old cases are nearly completed, and the average age of cases in the High Court is now 4 years, and the average age of cases in the Court of Appeal is about the same. We're aiming to further reduce these delays altogether. Also, there is buy-in for the judiciary-led reforms from the other arms of government. For example, the legislature responded with alacrity to the declaration and the recommendation of the board by enacting the Criminal Procedure Plea Discussion and Plea Agreement Act in a record time. The act came into force on the 3rd of June, 2024, and on the heels of its enactment, the Judicial Education Institute of the Senior Court of Belize conducted a sensitization program so that stakeholders were prepared for its implementation. Armed now with the new act, defense counsel are requesting more maximum sentence indications, and cases are being disposed of by way of guilty pleas without going to trial. Accused persons are more readily inclined to plead guilty, as counsel are equipped to advise their clients on the range of possible sentences. Through the combined use of pretrial tools such as maximum sentence indications and plea discussions, more cases are being resolved quickly. At the appeal level, we are able to resolve those matters despite the challenges we have still with transcripts. There were restrictions, as I alluded to, in relation to bails being heard only 1 day a week, and the Office of the Chief Justice issued a directive to judges that the hearing of bail applications should not be restricted to only 1 day per week, believing that such a restriction had no place in the proper administration of justice and could unduly infringe the rights of the accused. Consequently, bail petitions are now frequently heard, lessening the incidence of lengthy, unjustified pretrial detention. The Director of Prisons informs that the pretrial remand population is down from 50% to 35% of the prison population. we are endeavoring to reduce this even further. It is noteworthy that judges, attorneys, and other stakeholders have taken ownership of the declaration. I am told that defense counsel and Crown prosecutors have been referring to the declaration in their arguments to fortify their case against adjournments. Additionally, there is now waning tolerance for unnecessary adjournments, thereby reducing the backlogs. Prosecutors' files are better prepared, and so too are the defenses. The quality of work at the bar has improved tremendously. Judges of the High Court have cited the Needham Point Declaration in their written judgments. For example, Honorable Justice Nigel Pilgrim, Honorable Justice Derek Sylvester, Honorable Justice Raphael Morgan, and Honorable Madam Justice Candice Nanton, they have all referred and relied on the Needham Point Declaration to buttress their decisions. The numerous citations of the declaration within the past 6 months speak for themselves. The declaration has clearly assumed firm footing in Belize's jurisprudential landscape. And through the work of the Criminal Board, we now have the situation where the relevant non-lawyer stakeholders are now able to appreciate the important roles they play in the dispensation of justice. Pre-sentence reports are now being provided within 2 weeks, where formerly we had to wait for 6 months, and this is very welcomed. In keeping with our strategic plan and the recommendations of the declarations, we have established a sentencing guidelines committee and sentencing advisory committee, which are the first of their kind in Belize, and the sentencing guidelines committee has worked tirelessly and completed the draft guidelines, which are now being reviewed by the advisory committee. We expect to implement them in the next few months. This would assist judges to have a consistent approach to sentencing. Defense counsel would also be able to utilize the sentencing guidelines to advise their clients on pleas. I have chosen to highlight the aforementioned gains which we were able to achieve by operationalizing the Needham Point Declaration in a short space of time through the board's facilitation of dialogue, collaboration, and teamwork without having to request additional budgetary support from central government. The work of the Criminal Justice Board has truly been transformative. I am certain that with the precedent of collaboration that the board has set and the continued work of the board, the long-term solution will also materialize. Indeed, very recently, on the 1st of July 2024, we gratefully actualized a long-term goal with the commissioning of a brand new spanking courtroom that houses 5 courtrooms, judges' chambers, and offices. Collaboration and dialogue must continue. The Needham Point Declaration provides us with many tools in which we could engage with the other arms of government easily. It is evident that the declaration presented a clear roadmap to overcome the challenges and break through the barriers. Belize is better off for having quickly implemented it. I remain impressed with the high rate of disposal and clearance of cases and the collegiality between all stakeholders in the criminal justice system. All of this is as a result of the excellent work on the board. Additionally, judicial officers are providing great leadership to their staff, and they all have excellent work ethics. Consequently, we are providing more efficient and timely service to the litigants and the people of Belize. Looking forward, the board intends to action the short-term solutions, and in order to fortify the gains we've made so far, in September 2024, the Judicial Education Institute of the Senior Courts of Belize will be convening a high-level criminal justice reform conference advancing the Needham Point Declaration. Honorable Attorney General, you beat us to it. This may well be the second. The conference targets magistrates, prosecutors, forensic department, the Director of Public Prosecutions Chambers, the Attorneys General Chambers, Defense Bar, and Legal Aid. The conference will benefit from the expertise of experienced judicial educators and experts from the Commonwealth, and the conference chair is President Alice York Suhan. We look forward and we are satisfied with the strides we have made in Belize over the past 6 months, utilizing the declaration in breaking the barriers and reducing the backlogs. The Criminal Justice Board has made a difference. The declaration is an inspirational and aspirational document. As a foundational document, it provides comprehensive guidance to our board. The board will continue to assess our progress in relation to the declaration and recommend measures and policies to be implemented so as to ensure that our justice system becomes even more efficient. We are pleased that there is a great cultural shift in criminal litigation from an adversarial one to more collaborative approach. The focus is more on furthering the interests of justice rather than simply winning. It is apparent that in Belize, we have been able to transform and improve the criminal justice system in the short term. And we anticipate that delays in the criminal justice system will soon be a thing of the past. Thanks to the CCJ Academy for Law Neesham Point Declaration, which continues to guide us well and complements our own strategic plan. I thank you.
Thank you, Madam Chief Justice, for your very insightful remarks on breaking through the barriers. I was just warned by the President himself and his assistant to keep it short. However, I have the esteemed honor to introduce to you our distinguished featured speaker. I shall try to keep it short. His Excellency Dr. Mohammed Irfan Ali, President of the Cooperative Republic of Guyana and Commander-in-Chief of the Armed Forces, was sworn in as Guyana's 9th Executive President on August 2nd, 2020. His Excellency is the holder of a doctorate in urban and regional planning from the University of the West Indies, a Master's of Arts degree in manpower planning, a postgraduate diploma in international business, a postgraduate certificate in finance, a Bachelor of Arts degree with honors in business management from the University of Sunderland, and an LLM in international commercial law from the University of Salford. President Ali was a member of the Canadian Institute of Management up to 2017 and holds his PMP 2006. In his public sector career, President Ali served as project manager of CDB's Project Management Implementation Unit in the Ministry of Finance. He became a member of the National Assembly in 2006 and was subsequently appointed Minister of Housing and Water and Minister of Tourism, Industry and Commerce. I just have one last thing to say. President Ali has recently been voted Caribbean Global Leader 2024 for his sterling contributions within the Caribbean region, and just this past January was honored with the Global Africa Leadership Award. He is the current chair of CARICOM and president of Guyana, all 83,000 square miles of it. Home to the mighty Kaieteur Falls, the grammatically ambiguous chicken curry, and home to the reigning CPL champions. Ladies and gentlemen, please stand as we welcome His Excellency Dr. Mohammed Irfan Ali to the podium.
Thank you very much. Please allow me to adopt totally Kioma's, your entire salutation. And I would just add that indeed this room is filled with distinguished ladies and gentlemen. Put your hands together for yourselves. You are in Guyana, and we are, of course, leading on many issues, but one of the important issues is on climate change and environment. And I'm happy that the Marriott has given you a chance to appreciate the difficult environmental challenges that we have to face. And, you know, sometimes existing conditions give us a chance to reflect. And what seemed to be an extraordinary morning under the circumstances that we are meeting, some people would say, let us postpone until the AC is fixed. We can't think in this environment. But just a short while ago in history, these were the exact conditions under which men and women operated efficiently and effectively. I say that to reinforce the point on environmental changes and ecosystem changes, and how those changes can impact our behavior and our mode of operation. And it is the same with the structure of society, the law, and how we all interface, and it all interface in the dispensation of justice and life as we know it. These conditions also offer us an excellent opportunity to determine who present a greater new ball shine, whether it's Jerome Khan or Ramdani. You just look at their head and you will see what I'm talking about. You know, there are already some important observations here this morning. We were welcomed by what might be the longest welcome speech ever. And the list of salutation was definitely the longest I've ever heard. It was the longest journey to good morning. And as we reflect today on this conference, I want to congratulate the Chief Justice of Belize for giving meaning to a decoration. Many times at the end of a conference, a decoration is just a summing up of all the talking points, and it's dead at the end of the conference. But I think we need to applaud Belize. It is important for us also to appreciate that the criminal justice system does not operate in a vacuum. Sometimes we carried away with the indicators of crime and criminality, and we do not focus on the origination of crime and criminality. So, in speaking about crime and criminality, to reinforce the point, we immediately move to the stats, which in my opinion are the indicators of the problem. But in a room like this, it is important that we address the root cause of the problem. And in addressing the root cause, we will definitely address the entire tree. And that would determine the fruits of the tree. So, this criminal justice system does not operate in a vacuum. There are societal issues, environmental issues, cultural issues, economic issues, issues of values, new formats of normalization that we must confront as a region. And this is important. It might be a subject that is not politically correct or correct for members of the judiciary, but it is an issue. And I'll give you a small example. Maybe a few decades ago, Kioma would not be looked at in a serious manner, appearing before a judge with a decoration on his ear. Or, and these are, as small as they look, important things that we must examine. The normalization of behavior and behavioral changes at a global scale and the impact in the region, and how our ecosystem is responding to the normalization is an important part of the criminal justice system that we must address. And the best way to address this, to avoid the political risk, the legal risk, is if we do it as a community. And it is for that reason, I believe, that a gathering like this allows us the opportunity to address major regional issues as a community. And as a community, we can take collective ownership and reduce the risk that sometimes prevents us from making bold moves and taking bold steps. And that is an important aspect of a gathering like this. It helped to mitigate important risks that policymakers may sometimes weigh in determining policies, parliaments in determining changes in legislation. But if we address it as a community, we'll be able to deal with that risk. Now, there's another area that is directly related to the criminal justice system. That is political stability, the rule of law, and democracy. The criminal network and enterprise feed off of certain things and elements. If there is political instability, if the rule of law does not exist, if society operates in an undemocratic or in an undemocratic environment, criminality feeds off of that. So it's very important also that in examining the entire ecosystem surrounding the criminal justice system, that political stability, the rule of law, and democracy forms an important platform for the system to operate under. Then there's a third plank of the issue. And this, I want you to take cautiously, because there can be misinterpretation. But I want us to examine it with a very open mind. A concept I've been thinking about: judicial predictability. We hear a lot about policy predictability. And what do I mean when I speak about judicial predictability? The soundness of decision-making in the judiciary, the structure of the judiciary, the quality of decisions, and importantly, the consistency of decisions are important elements, in my humble opinion, of judicial predictability. If you examine, and maybe at conferences like this, Justice Anderson, we can do some case study. If we examine similar issues by different magistrates across the region, this is not Guyana issue or Trinidad issue, and see the variation in decision, then it exposes the system to all sorts of assertions. And we have to guard the system. And the only way we can guard the system is if the elements of judicial predictability that is based on fairness, justice, is kept intact. That is the third issue I want to pose for the conference among the three. You know, I always tell my AG, quality lawyers must be matched with exceptional judges, supported by a legislative framework that is fit for purpose. It's important. It's important, especially in this era of AI, that our judges and the judiciary itself is given the necessary attention, because 2 years from now, our judges will be in an environment in which they will quickly need to decipher what is real and what is unreal, based on arguments presented. What is AI generated and what is not AI generated. And that requires a whole different mechanism, a whole different support system, a whole different deployment of technology to support their work. So this era of digitization and modernization that is taking place within the judiciary is really, we're just scratching the issues at the moment. From a national perspective, we are way behind the curve when it comes to digitization. And unfortunately, the developing world is faced with this crisis continuously. And it's an output of the environment in which we operate. When we were fighting to come out of colonial rule and slavery and indentureship, the rest of the world was moving towards industrial revolution, manufacturing. By the time we got out of that and we started to struggle to come up to be competitive in food production and manufacturing and industrial development, the rest went to services industry. By the time we struggled to get there, you're at digitization. And we are always forced to match the speed of change globally without understanding where we have started or where was our starting point. And this is the same with the judiciary. The speed of change. You know, here in Guyana, for example, we have a whole new sector, the oil and gas, that brings with it the most modern insurance issues, environmental issues, that requires our judges, our lawyers, the entire ecosystem that support the legal framework of the country to be up to speed, to read, to be re-educated in some cases. So the system itself needs to address this issue of continuous education. And that is why the Academy, the CCJ, is so critical. But that Academy, in my humble opinion, must focus on the emerging issues. And maybe through an accreditation process, design short executive programs that give our lawyers and judges specialized training and specialized certification, maybe international certification too, on key issues and challenges that we are facing now and we will face in the future. And I want to assure you, like I did in a meeting with President Saunders, that we in Guyana will fully support the continuous education advancement of the CCJ in the region. We believe that this is an important area through which Guyana can make a contribution, and we would definitely welcome the opportunity to partner with the CCJ in this endeavor. So, some of the issues. Let me just point to some indicators, not the problem, some indicators that reinforces the point that we do have a problem in the region. A 2023 study by the Commonwealth revealed excuse me, that 4 out of 10 countries with the highest murder rates globally are Caribbean Commonwealth states. The rate of violent deaths in CARICOM member states is nearly 3 times the global average. Firearms are involved in over half of all homicides on average, with some countries experiencing rates as high as 90%. Between 2016 and 2020, nearly 31,500 people in the Caribbean lost their lives due to interpersonal violence, with more than 60% of these deaths taking place in CARICOM and its associate member states. More than half of the homicides committed in the Caribbean region involve the use of a firearm. Young men under 30 years of age are both the most common victims and also they are the ones committing the crimes. Estimates for 2020 show that on average, 90% of the victims of lethal violence in CARICOM member states were men, exceeding the global average of 83%. Now, these are the indicators that we do have a problem. But what are also some of the root causes that we must address? And many times we are of the mistaken view that these problems are problems for the executive or problems for the policymakers. But these are really problems for the system, the ecosystem. If the institutions are not strong, if we don't build strong, relevant institutions, then we will not build for the future. And that is why our focus must be on building institutions. Now, except the recent history of the U.S., one of the things that the U.S. prides itself of is the strength of its institutions. Now, how do we build institutions that can withstand transition in governments? We also have to change some concept. In the region, we say there is a change in government. Yeah, there's a change, but how do we move to an era where we can have transition in governments? Because that is a function of democracy. The people vote, you have changes, but there's a transition. And that is an important aspect of political stability. What constitutes this transition? How do we have continuity in policies in that transition? Policies that are fit for purpose, policies that are relevant, and policies that are important for the improvement in the system. So in examining some of the fundamental issues, we have economic challenges. And in this region, it is magnified by single events. Hurricane Beryl, in 45 minutes, Attorney General, has sent people from the middle development class back to the poverty line. The entire fishery sector in Barbados wiped out. in 45 minutes. The beaches that are an important part of the revenue generation that is critical to rebuild the fishery sector, gone. Grenada, Jamaica. In an environment in which there is already great economic pressure, our region is now faced with these difficulties. So how does the ecosystem respond? How does the ecosystem respond? And the ecosystem is not the executive. The ecosystem is everything, because a problem affects the entire system. If we don't have crime, we have less load on the judges. The system works like that. But under these conditions, there is greater likelihood of increased crime because of a new economic pressure that Beryl would have brought. So from an institutional perspective, we have to address this before it becomes a problem. But we are not trained historically to look at the problem from that perspective. That is one issue. The economic challenges and the changing nature of the economic challenges. Climate challenges and the changing nature of our climate challenges. Some of the most important cases in India on criminality are in relation to biodiversity and climate issues. So this is going to be something that we'll have to address now and in the future, especially in a world in which in the last 60 years we have lost more than 60% of our biodiversity. So new environmental laws are coming on stream to protect our biodiversity. So climate and environment is another important aspect that we cannot avoid. Development challenges, infrastructure, education and social services, and technology. Why is this important? If you look at the Neham's Declaration, it does not deal only with the dispensation of justice. It deals with a system through which you can have efficiency and reliability in that dispensation and reduce costs of the dispensation. But if we can take it a step forward and examine, and I think that is the reason we have all different stakeholders in this room, examine how we can address the associated issues in relation to crime and criminality. Development challenges, infrastructure. And I can give you some examples here in Guyana. In the last 3.5 years, as president, I can account for those years, where key investment in infrastructure would have changed mindset, would have changed perception, and would have given direct results in terms of the reduction of crime from those areas and greater involvement in what I would say positive living. There are concrete cases that we can showcase. So infrastructure is directly related to quality of life, economic opportunity, and also changing mindset and perception. You know, you go to some countries and fortunately or unfortunately, you would get a warning. Don't go to these areas. Or these areas are high-risk areas. If we have determined an area to be a high-risk area, then how do we de-risk the area? Where is the conversation on de-risking the area? And this is an important part of the ecosystem that surrounds criminality. How do we apply our minds in the creation of policies that de-risk high-risk area? And what are the elements of that de-risking? And then we will see it takes us to a traceability study on levels of education, dropout rate, access to education, quality of teachers. If there is a particular area that is prone to a particular crime, then the education system must put in the schools in that area teachers that are trained and equipped with a special skill set to deal with that particular issue so we can change the mindset. You can change that thinking process in the system. And that is how deep we have to go in resolving these issues. It's not a one-size-fits-all. It is developing systems that are responsive to the situations on the different conditions. It will be a great work if one is to do an analysis on a thinking process, the mindset between same people, same countrymen and women, but living in two different areas. Living in two different areas. Unless the system supports this realignment, then we will not be dealing with the criminal justice system in totality. We can go and adopt all the legislations the IDB want to recommend to us. We can bring all the best practices. But if we do not fix the ecosystem, that is not only an issue for the judiciary or the dispensation of justice, but it's a problem for all of us, for the churches, parliament. Then I believe that we will continue to plaster the problem and not address the foundation. The cracks would appear at different time in a different form. So it is important that a conference like this, just like the heads of government, we looked at the problem, and you know there were a lot of headlines on some of the comments that were made in relation to the judiciary. But it's good for debate. It's good for us to have these open discussions. That is why a conference like this must also go beyond the scope of what you do every day, administer justice, and point to some of these issues because you see it from a different lens. You see it at the end, so that we can develop a holistic approach and construct an ecosystem that is relevant for this region. You know, we have Attorney General here, we had a former Minister of Public Security, Kemraj Ramjitan here. We have many political people in this room too. And in our small societies, and sometimes the big societies don't get this too. In our small societies, you know everybody. the amount of photos I took in the last 4 years is couple lifetime. And I'm sure in those moments, I took photograph with everybody, the good, the bad, the not so good. Small societies have different challenges. And our challenges are more magnified. We have to learn to put our brain power together, and we have enormous brain power in this region, to design and develop solutions that meet our needs and our problems. We can complain forever that the guns are coming in from outside of our borders. All of us know most of the guns come in to the region from the US. Justice Anderson, we heard that there was a special prosecutor assigned by the US to deal with this. Maybe we should ask how much persons would have been prosecuted. We are asking these questions from time to time, because the indicators are pointing to the guns as a major cause of the problem, and the root of the guns is extra-regional. It requires a certain level of frankness and openness to deal with these matters. And we have to. Before I lose this thought, when I spoke about quality lawyers require exceptional judges, we must also know that the strength of these cases and the strength of the decision also require quality police work and quality prosecutors. And we have started a process of addressing this. But as a region, again, for the CCJ, maybe we can look at many of the universities. We have partnered with many universities from the UK now. We can look at an executive program from the CCJ for prosecutors, especially in the matters that we're dealing with and in the type of prosecution that we have here. And that is something, too, I think, the CCJ can champion, a specialized program for prosecutors and how we bring our prosecutors up to speed. Funding is another challenge that we have. Major challenge. I just because of what you just went through, AG. Let's look at Barbados. In one day, the government of Barbados must now realign their entire budget. Everything they had planned for judicial reform, for this strengthening and that strengthening, they now have to make a decision. Do we put it there? Or do we deal with the fisher folk who are now without income? And it's important that the judiciary understand the funding mechanism of the country. Here in Guyana, we are a bit fortunate now, and we have been able to put a lot of resources in the infrastructure and the strengthening of the judiciary. And the judiciary has been doing enormous work in innovating and modernizing. And if you have the chance, Chancellor, I would say maybe we can have some tour of some of these facilities. In COVID, I was very proud of our judiciary in COVID when we introduced concept of containerized courtrooms. And we saw how effective that was and how it kept the wheels of justice going, even in the harshest of conditions. And that is a type of innovation that we must address. the other issue, I've exceeded my time. I plead with you. My plea is for some additional time. Camera, as you'll move the motion. Now, I want to just address three more issues. One is the regional cooperation. I think that we need to believe more in ourselves as a region and trust more ourselves as a region. We need to have greater networking among our judges. We need to have greater networking among our lawyers. And we need to now think strategically about whether individual systems, given the size of our economy and population, are best suited for us, or whether we should develop regional systems to resolve some of these major issues. The CCJ is an exceptional example of a regional system that is working for us. And I continue to encourage all those who are not part of the CCJ to make the right decision and be a part of the CCJ in this region. How many times in these conferences do we examine international charters and treaties that governments are entering into? For example, have we ever examined the outcome document of COP? Have we ever examined the SDGs and its consequences in the work that we do? Because all of these things, inherent in all of these documents that governments are signing on to, are issues concerning your sector. But do we spend time and I'm sorry to put more burden on the CCJ, but do we spend time on examining these issues and provide briefs, provide guidance on these issues? So I want us to also look at that. Transnational crime, technology and digitization, the whole global health crisis, media and information flow, the speed of information is different today. News is instantaneous, whether it's in the courtroom or out of the courtroom. That is why we have to design systems that ensure factual information is out there. We also have to examine the global trends in the criminal justice system. I already mentioned education and professional development, the role of international organizations and NGOs, because sometimes we have so many NGOs operating in our region that sometimes many of them are part of situations that we have to deal with. So we have to also examine the role of NGOs and how NGOs are operating. You know, and any NGO can come into the region and operate. Let us see how many NGOs from this region can just go into another jurisdiction and say, oh, we're NGO from Guyana, we came here to do an analysis on this and give you some thoughts. It's important because these NGOs sometimes become important bodies of influence. So we have to examine the role of NGOs, they have an important role, but these are things that are part of this ecosystem that we must examine. Those who would have served in cabinet as ministers of security, attorney generals, you know, sometimes depression, difficulty, and challenges that comes. Important also is for us to understand the changing consumer habits in the region. The changing consumer habits, not only with soft drink and beer, but the changing consumer habit and where that habit is being satisfied. The Guyana Police Force will tell you that today we have, because of the changing market conditions elsewhere in the world, it is cheaper now to import marijuana in different form because it's economics, competitive environment. The trade open up, it becomes cheaper, it's imported. Different forms of drugs. Changing consumer habit, being normalized in the school system. Gangs just do not fall out of some sky in the school system. It comes from the community, it comes from the home. The weakness in the system. The weakness in the system, and we, forums like these, must be bold enough to speak to these issues. The churches, the family, the home, the community. It is this collective of brain power, of distinguished men and women, that also need to address these challenges and issues. And that, in my humble opinion, would allow us an opportunity to address the root cause of challenges and consequences in the criminal justice system. Thank you, and God bless you. Sorry. I now declare the conference open.
You may have your seats. We thank Your Excellency for those very brief remarks and for making the feature address. We hope you will join us on more occasions like these. We will heed to your words of encouragement and encouragements to advance the needs of a more modern criminal justice system and looking at the ecosystem. So we thank you. Let's give His Excellency another round of applause, please. We also thank the Honorable Attorney General, Justice Anderson, Chancellor Cummings-Edwards, Chief Justice Blenman, and Ms. Salazar for their remarks this morning. Give them a round of applause, please. I want to, before we bring the formal ceremony to a close, I want to recognize the hard work of the steering committee which planned this conference. The committee was chaired by the Honorable Attorney General, along with Justice Anderson of the CCJ, and they were ably assisted by the Honorable Madam Justice Alice York Suhan, President of the Turks and Caicos Islands Court of Appeal, the Honorable Madam Justice Simone Morris Ramlal, the Honorable Madam Justice Deborah Kumar, Mrs. Indira Ananjit of the IDB, Mr. John Coombs, formerly of the CCJ, Ms. Shoshana Lal, Assistant Solicitor General of the AG Chambers, and a team of hard-working officers from the AG Chambers, including the Permanent Secretary, Ms. Adele Clark, and yours truly on behalf of the Bar Association of Guyana. They deserve a round of applause. We have a very special presentation we want to make today. I want to invite His Excellency, I want to invite the Honorable Attorney General and Justice Anderson to be a part of this presentation. And I think somebody, oh, we are ready with it. And if you want to know what's inside, can I tell them, Chief, what's inside?
Public transparency.
It's a clock, because we're on time. Thank you all so very much, ladies and gentlemen. This brings us to the end of the formal ceremony. We are going to have a break right now. I invite all of you to convene in the foyer. We're going to transform this room into the conference setting. Thank you so very, very much. Many of you may want photographs with His Excellency. I'm sure he'll be kind.
It might be best to do the conference in the yard today.
Thank you very, very much, everyone.